Structure of a patent specification. We had already seen a patent specification, be it a provisional or a complete, has to be filed in a particular form, that was Form 2. And Form 2 had a particular structure. There was a title of invention, applicant's name, preamble to the description. Then if it's a provisional, then it will start with the statement, the following specification describes the invention. If it's complete, it starts with the preamble, the following specification particularly describes the invention and the manner in which it is to be performed. Then you had description, then you had claims, and it ends with signature and date of the person filing it, and it also has an abstract. Now this is, and we have seen the provisions of the Act where the structure of the specification is described. Now let us look at an example. Now what you have here is patent that is filed before the United States Patent Office. We are using this as an example because these are the published patent applications, and for the sake of illustration, the patents published by the United States Patent Office are much more descriptive, and it is easier to understand the various parts of the specification. Following this, we will also be showing you an Indian application so that you can understand. It is by and large the same, but the formatting in which the patent specification is done by the US Patent Office is much more easier to understand, and it has all the details in one place. So you will find these numbers next to United States 19, 12, then there is 10, 43, all in brackets, 54, 76. Now these are universal codes which are used by patent offices regardless of the office in which the patent is granted. So code 76 will be for the inventor's name, code 22 will be for the date on which it is filed, then code 57 will be for the abstract. The advantage of these codes is that regardless of in what language the patent is written, now a Japanese patent will be written in Japanese language, so for the Chinese patents in the Chinese language, European patents could be in French, it could be in English. So you find that because there are patents are written in different languages, these universal codes helps us to navigate these documents even if it is in a foreign language, for us at least to understand what is where. I mean, with regard to numbers, publication date 43, you quickly see the code and you will know that that is the publication date. So the universal codes are used in different specifications by different patent offices, but the code, the numbers tend to remain the same. Now, and this is what is known as bibliographical detail. Bibliographical detail will give you the details about what are the bibliographical details about the patent, the inventor's name, application number, the date on which it was filed, the classification, the title, patent office in which it is filed. You will also see a barcode which is for administrative purposes. The US office has also given a barcode. Now you find the abstract also. The abstract, as we had just seen in Form 2, comes after the signature and date. In the Indian Form 2 it comes after, but here it is presented in a different way. The abstract is presented upfront. Now the abstract describes a combination pen with correction marker providing a user with a writing utensil and a correction method in a single device, and it further describes what the abstract is. Now the abstract we had seen has a particular function. We saw that in Rule 13, we had seen Rule 13(7)(a) and B. What are the functions of the abstract? Now abstract the world over perform similar function. They describe the invention and it is a concise summary, and they indicate the technical field to which the invention belongs. It describes the technical advancement, principal use of the invention, and if it is a chemical substance, it also may contain a chemical formula. So this is the abstract. Now let us see what else is contained in the patent specification. For most mechanical devices, you will find drawings. Now here is a drawing. Now the drawing will figure first. This is a further drawing, figure 1, and you find that there is a figure 2, and all the drawings will be cross referenced. Now we come to the patent itself. Now the written part, you will find that there is a title, combination pen with correction marker. Now you can note this number. US 201200935628, and you can search it on Google, google.com/patents, which is the patent database search for provided by Google, or you could go to the US Patent Office website and you can search for these numbers, and the numbers will throw up these documents. So, if you want to search any other patent, you could go to google.com/patents and you could write the title of the invention, or the if you have the claim, then you can write the claim. There is an advanced search feature, so it will give you these documents. So, now here you will find that there is a title, combination pen with correction marker. Now, the first section of the specification will be a descriptive section. So, if you have to classify the specification into two parts, you will just say the specification comprises of two parts, the descriptive part and the claim. So, the descriptive part has various subheadings. So, the descriptive part, and we had already seen that the patent specification shall start with the title, there shall be an abstract, there shall be a descriptive part, then there shall be claims, and then there shall be the signature. I mean, we saw that in the form 2. Now, the background of the invention may start with the field of the invention. The field of the invention will tell you to what field of technology does the invention belong to. Then it may also have a heading called description of related art. So, because inventions are never created in abstract, there is always a prior knowledge or a prior art or a relevant art for the invention. There could be description of prior art. The description of prior art could be general statements, as you can find here, or it could be specific statements like referring to an earlier patent or referring to a patent number or to a scientific article or a research publication. So, description of the related art could be through reference, or it could also be through a general way as it is described here. So, you find some background given, then you have the summary of the invention. So, till para 7 what was described was, and you can see here, US patent number 635943. So, that is a description to an earlier existing invention, what we call a prior art. So, prior art references can be, you find another description to a patent number here 4600327, again an existing invention which is related to this. So, you could have a broad description of the prior art without specific references, or you could also have specific references of prior art which have already been patented, as you can see here. Now, para 7 ends with the state of the prior art. What is that existed before this invention came into being? Now, summary of the invention will talk about the invention. The present invention relates to a pen so and so. Now, it will describe various objects. Now, you can see that it is an object of the present invention, another object, and in view of the foregoing disadvantages inherent in the prior art. So, the prior art, we understand the prior art to have certain disadvantages, and we can understand that this invention overcame those disadvantages. So, the summary of the invention will have the objectives and the problem that was solved. Problem as in the problem in the prior art that was solved. Now, following the summary of the invention, there is a brief description of the drawings. Now, you saw figure 1 and 2. Now, figure 1 is explained here, figure 2 is explained here. This is a description of the drawing in words. They are all perspective view. So, perspective view drawing, there are cross section view drawing, split view drawing, blow up. There are different kinds of drawings that can be that can accompany a patent. Here you have the perspective view drawing. Now, following the description of drawing, the next heading will be detailed description of the drawing. Now, in the detailed description, you will actually tell how the device is constructed, what are the parts, how the parts work with each other. This is the detailed description. Now, in the detailed description, you are going to find these numbers: correction marker in bracket 100, correction marker 100, tubular body 102. Now, if you go back to the drawing, all these parts were marked in the drawing. okay, 100, the correction mark and 100. Now in the drawing they are not described, I mean they are not explained in the drawing. That's a requirement in patent law. You cannot have written statements or written descriptions in the drawing. The drawing can only be numbered unless it is a flow diagram. And if it's a flow diagram, and we saw that in rule 13, the only place where you can have words within a drawing is in the case of a flow diagram. Other than that, the drawings will only bear numbers. So because these numbers are there, when you have a detailed description of the drawings will actually cross refer those numbers, what we just saw here. So these are all the cross references. Tubular body is 102. Wherever tubular body is repeated, you repeat the number. Ink cartridge is 104, pen tip is 114, and so on. So it's just how, so you when you see these numbers, you know, you can look back into the drawing and understand which part of the marked drawing is the part that is described here. So tubular body is 102, so on and so forth, you will understand that. Now this description of the drawing, because it's a mechanical invention, there is no illustration required because the description of the drawing itself describes it. Whereas for a preparation of a chemical substance, you will find examples, or example 1, 2, how this is prepared, the different methods by which it can be prepared, and if there is a disadvantage in a particular method, that advantage is described. So illustrations and examples are normally there where there is a method involved in preparing something, say a chemical substance. In this case you do not find that, because this is only a mechanical invention and the descriptive part has described it. And finally you have the claim. The claim in a US patent begins with the statement what is claimed is. In India it is I claim or we claim. What is claim? A combination pen with correction marker comprising, now comprising colon, if you can see that. Now comprising colon allows you to split a sentence into various components. You can see that there are various clauses here ending with semicolon, and finally you have and you have the clause ending with a full stop. So by convention, no matter how complicated the invention is, claims are written in one sentence. It's a convention, it's followed over the world, all over the world. So by convention, claims are written in one sentence. Sometimes if the invention has multiple parts and if the parts interact with each other in a particular way, it takes time for people to understand that. So that is why you will find that colon and semicolons are used to show that there are different clauses. Now let's slowly try to read this. This is an invention that comprises a combination pen. 1. What is claimed is 1. A combination pen with a correction marker comprising. So there is a pen with a correction marker. A tubular body extending an entire length of the said combination pen with correction marker. So there is a tubular body. An ink cartridge housed within the said tubular body. There is a cartridge inside the body. A pen tip connected to the end of the said ink cartridge, where the said pen tip dispenses an ink supply from within the said ink cartridge. So the pen tip is connected to the ink cartridge. A twisting grip coupled with a plunger mechanism attached to an open end of the said tubular body, where said plunger mechanism moves said pen tip from an extended position and a retracted position when turning said twisting grip, when turning the said twisting grip. A correction reservoir fastened to an opposing end of said ink cartridge, where the said correction reservoir stores the supply of correction ink, and a sponge inserted within the said correction reservoir, wherein the said sponge dispenses the said supply of the correction ink from the said correction reservoir. Now you will see too many saids there. It is just that the said means the earlier referred or the one referred above. Okay. So that's again whatever you see here has come to us by long years of patent drafting, which is conventionally followed by various patent offices. Now, so we understand that here this is not a combination which is just a list of things there. If had it been a list, then you will find that a combination pen and a correction marker comprising a tubular body, an ink cartridge, a pen tip, a twisting grip, a correction reservoir and a sponge. This is not, then it will just be a list of things, but here the list is there nevertheless, but the list is also connected to the various parts are connected. They actually tell you that there is a tubular body and there is a pen tip which is connected to an ink cartridge, and the ink cartridge dispenses the ink into the pen tip. Then there is a twisting grip with a plunger mechanism, and there is a correction reservoir, and there is a sponge. Now all these things are described in a way in which when we read it and when we look at the diagram, we are able to understand the working and the construction of the pen itself. So this is how a claim is drafted. This is one of the ways in which a claim is drafted. Now claim 2 cross refers to claim 1. So a combination pen with correction marker of claim 1, wherein the said twisting grip includes a tip encasing to house the said pen tip to prevent said supply of ink from drying. Now that is a small modification to help the ink from drying. Now claim 5, a combination pen with correction marker of claim 1, wherein the said sponge includes a angled tip, again a small modification to the existing invention, claim 1. 6, the combination pen with correction marker of claim 1, wherein the said sponge has a blunt tip. The earlier one, 5th, was angled tip, blunt tip, very small variations too, so that these small variations exist so that a competitor will not make small changes and say that my invention is different, I am not infringing. So blunt tip, angle tip, these are all variations which a person could do, a competitor could do, and claim that you had claimed tip, mine is blunt tip. So just to avoid that, you will find that the claims, the enumerating the different aspects of an invention. Now here claim 1, which we just saw, is what we call an independent claim. It is independent because there is no need for you to refer to anything else to understand the claim. Whereas claim 2 onwards, all the other claims here are dependent claims, and we call them dependent because you cannot get the full essence of those claims without having to read some other claim. Claim 2 cross refers to claim 1, claim 3 cross refers to claim 2, and when you read claim 2, it cross refers you back to claim 1. So you cannot read any of the claims 2 to 8 without reading claim 1. So 2 to 8 are dependent claims because there is a cross reference to an earlier claim. Claim 1 is an independent claim. So claims broadly fall into two categories. The idea between a dependent claim and an independent claim is that independent claims can stand on their own. If a dependent claim that is attached to an independent claim is attacked for lack of inventiveness or lack of novelty, then the dependent claim alone can be revoked or nullified. Whereas if the attack is on the independent claim itself, saying that the independent claim does not have novelty, it lacks novelty or it lacks inventive step, then the independent claim will be revoked, and the reason the independent claim is revoked, all the dependent claims will also have to be revoked. So this is another convention in drafting where dependent claims, if they overlap with the prior art, to the extent of their overlap, they may be amended or they may be revoked without affecting the independent claim. So if you challenge a dependent claim alone without challenging the independent claim, then the dependent claim alone can be given up and an amendment can be passed by renumbering or restructuring the claims, and the invention will still continue in the amended form. Whereas if the challenge is on the independent claim, a competitor challenges the independent claim or the patent office questions the independent claim based on prior art, and if the independent claim is revoked, all the dependent claims will also be revoked automatically as a part of the fact that because they were dependent on the independent claim. Now let us look at this is a US application, and you saw the structure of the US application. Now let us look at an Indian application. Now this is how form 2 looks. Now this is an application which was amended on a particular date. The form 2, there is provisional / complete, depending on which you use, you will strike off the other. And there is a title, the title was amended, so you can see that it was struck off and it was written back again, and the applicant's name is here. Now we are using this as an example because this patent resulted in the Bajaj TVS dispute, which is now pending before the High Court at Madras. So it starts with the description. You don't find the headings which you found in the US patent application. It just starts, the invention relates to, but we understand the field of invention, we can understand this to be in a order, in a particular order, though the subheadings are not here. Now it just starts, it describes the invention, how it works. There is a cross reference to a US patent, you can see that 4534322, and you have figures here. What we saw, the brief description of the drawings, figure 1 shows figure 2, and there is a detailed description of the drawings. So what you find in parenthesis, in brackets, are the parts that are, we don't have the drawing here, drawing is in a separate document. So the parts that are spark plugs are numbered 21 and 22, sleeve is numbered 23, the similar. So I'm just, now you'll get a picture. What you saw in the US application, which had particular subheadings, though the Indian application do not have those subheadings, nevertheless they still follow the same scheme. So reference to figure 1, so this is the detailed description of the drawings, and it's done in a similar manner, similar fashion. This is a public document, so you can go to the Patent Office website and you could download it if you are interested in reading it. And then you have some results, test results, which they have tabulated. You have the claims finally, we claim. This is the Indian way of doing it, we claim, and the claim number 1. In India, you will have to mention the numbers of the parts within the claim also. So spark plug, the number has to be referred. So that is claim 1. Now claim 2 is a dependent claim as claimed in claim 1. So it refers it back to claim 1. Claim 3 is again dependent, claim 4 is again dependent, claim 5 is again dependent because it says an improved internal combustion engine as claimed in any of the preceding claims. So 1 to 5, it's again dependent. Claim 6 is an independent claim. Claim 7 is what we call an omnibus claim. It used to be that omnibus claims were granted before, but now it is not granted. The Patent Office has a manual, the Patent Office manual. The manual clearly says omnibus claims are no longer granted, where they say substantially as herein described and as illustrated in the drawings accompanying the specification. It's an omnibus. It's just reiterating what is already covered in the specification. So you have the signature of the agent. If the inventor is filing in his own name, then it will be the inventor's name. So and signature and date, which again form 2 had mentioned that it shall end with the date and the signature.